Before we begin, a quick and important disclaimer. The information provided in this video regarding 401k plans, divorce laws, and retirement asset division is for educational and entertainment purposes only. It does not constitute legal, financial, or tax advice. Divorce law and retirement regulations vary significantly by state and are subject to change. Historical trends discussed do not predict future outcomes. You should conduct your own due diligence and consult with a qualified attorney or certified financial planner before making any decisions regarding your personal finances or legal standing. Imagine it is 1994. You have spent 15 years climbing the corporate ladder, diligently contributing to your 401k, watching the S&P 500 climb during one of the greatest bull markets in American history. You believe your future is secure. Then, a single envelope arrives at your door, or a single conversation happens in a kitchen that changes everything. In the 1990s, a quiet revolution was happening in American courtrooms. For the first time, the 401k wasn't just a nice-to-have workplace benefit. It became the largest liquid asset in the American household, often surpassing the value of the family home. But as divorce rates hovered near 50%, thousands of Americans discovered a terrifying reality. The money they thought was theirs was legally a marital asset, and the rules for splitting it were a labyrinth of bureaucratic nightmares that could vanish 30% of the value in taxes and penalties if a single line of paperwork was signed incorrectly. Today, we are performing a deep dive autopsy on the 401k divorce crisis of the 1990s to show you exactly how the foundation of modern retirement division was built, why so many people lost their shirts, and how these historical precedents still dictate the safety of your retirement savings today. The 1990s represented a massive cultural and systemic shift in how Americans viewed wealth. We were moving away from the gold watch era of defined benefit pensions, where a company promised you a monthly check for life, and into the era of the 401k or defined contribution plans. This shift fundamentally changed the stakes of a divorce. In the old days, you might split a future monthly check. In the 90s, you were splitting a pile of cash that was fluctuating in real time with the tech boom. This created a high-pressure environment where emotions met complex ERISA, Employee Retirement Income Security Act, laws. To understand why this was so explosive, we have to look at the Qualified Domestic Relations Order, or the QDRO. In the 1990s, the QDRO became the most important document most people had never heard of. If you were getting divorced in 1995, you couldn't just tell the judge, "Give her half my 401k," and have the bank cut a check. If you did that, the IRS would view it as an early withdrawal. You would be hit with an immediate 20% federal withholding, state taxes, and a 10% early withdrawal penalty if you were under age 59 and a half. On a $200,000 account, you could lose $60,000 to $80,000 just by trying to be fair. The QDRO was the magic key that allowed the movement of money from one spouse's 401k to an account for the other spouse without triggering those devastating taxes. However, in the 1990s, many family law attorneys were still catching up to the complexity of these plans. We saw thousands of case studies where a general practitioner lawyer would draft a divorce decree that was unqualified. This meant the 401k plan administrator, the person at the big corporation or the mutual fund company, would look at the court order and say, "This doesn't meet our specific plan requirements." Rejected. This left couples in a legal limbo. The divorce was over, the couple was living apart, but the money was stuck. Sometimes it stayed stuck for years while the market moved. Imagine a spouse who was awarded 50% of a 401k in 1998, but because the QDRO wasn't processed until 2001, they watched the dot-com bubble burst, erasing half the value of the account before they could ever touch it. The question of who bears the loss of market fluctuations during the delay became a landmark legal battleground in the 90s. We also have to discuss the marital portion calculation, which became a mathematical nightmare for 1990s accountants. If you started your 401k in 1985 but didn't get married until 1990, and then divorced in 1999, how much of that money is actually marital? Only the contributions and the growth on those specific contributions made during the years of the marriage are typically considered communal property. In the 1990s, tracking this was significantly harder than it is today. We didn't have instant digital downloads of 10 years of statements. People had to dig through shoeboxes for paper statements from 1991 to prove what the starting balance was on the day they said, "I do." If you couldn't prove the premarital balance, many courts would default to assuming the entire account was marital property. This led to a massive wealth transfer based purely on a lack of record keeping. Furthermore, The 1990s saw the rise of the offset strategy. Because the housing market was also booming, many couples tried to trade assets. One spouse would take the house, and the other would keep the 401k. On paper, if the house had $100,000 in equity and the 401k had $100,000 in cash, it looked like a fair trade. But this was a trap. The house was often post-tax equity, meaning if you sold it, you kept the profit up to certain limits. The 401k was pre-tax money. If you kept the $100,000 401k, you actually only kept about $70,000 after eventual taxes. The spouse who took the house in 1996 often ended up significantly wealthier by 2006 than the spouse who kept the retirement account, simply because they didn't account for the deferred tax liability inherent in a 401k. This era also introduced the separate interest versus shared interest approach. Under a separate interest QDRO, the non-employee spouse could take their portion and treat it as their own, often rolling it into their own IRA. This gave them control over the investments. Under a shared interest approach, they simply waited until the employee spouse retired to start receiving a portion of the checks. In the 90s, as the individual investor culture took hold with the rise of E-Trade and CNBC, everyone wanted the separate interest. They wanted to take their half and put it into the hot tech stocks of the day like Cisco, Microsoft, or AOL. This period was the Wild West of retirement litigation. The lessons learned during this decade formed the basis of how we protect assets today. People learned the hard way that a 401k is not a bank account. It is a legal contract governed by federal law. If you didn't respect the contract, the government took a massive cut. As we move into the next parts of this masterclass, we will examine the specific tax loopholes that were closed, the valuation date traps that ruin lives, and how the 1990s redefined the financial death of a marriage. Understanding this history is the only way to ensure that your modern-day portfolio doesn't fall victim to the same procedural ghosts that haunted the previous generation. To truly grasp the volatility of the 1990s 401k landscape, we have to look at the specific year 1997. This was the year the Taxpayer Relief Act was signed, and the stock market was beginning its parabolic move toward the stratosphere. For a couple in the middle of a divorce in 1997, the 401k was no longer just a retirement fund. It was a ticking time bomb of valuation. Imagine a man named Robert working for a major manufacturing firm in Ohio. Robert had $450,000 in his 401k, largely comprised of company stock and aggressive growth funds. His wife, Sarah, was a stay-at-home mother who had supported his career for 20 years. In the eyes of the 1990s legal system, Sarah was entitled to a significant portion of that growth. But here is where the historical trends get dangerous. The valuation date. In 1997, the time between filing for divorce and the final decree could span 18 months. If Robert and Sarah filed when the account was worth $450,000, but by the time the judge signed the papers the market had surged and the account was worth $600,000, who gets that extra $150,000? In many 1990s case studies, the lack of specificity in the initial filing led to multi-year litigations just to determine the cutoff point for growth. If the decree said Sarah gets $225,000, she missed out on the market boom. If it said she gets 50%, Robert felt robbed of his post-separation contributions. This created a scenario where the 401k plan administrator became the most powerful person in the divorce, yet they were often the most difficult to reach. The role of the plan administrator in the 1990s cannot be overstated. Unlike today where you can log into a portal and see your QDRO status, back then, everything moved via snail mail and fax machines. A plan administrator at a company like General Motors or IBM dealt with thousands of these orders. They were not lawyers, they were HR bureaucrats. If a QDRO did not mirror the exact, idiosyncratic language of that specific company's plan, it was rejected. We saw instances where a spouse would wait 6 months for a response, only to receive a rejection letter, because the document used the word balance instead of segregated account. During that 6-month delay, if the market dropped or if the participant spouse took out a 401k loan, the non-participant spouse's future was effectively liquidated without their consent. This leads us to the 401k loan trap, a specific historical trend that destroyed thousands of settlements in the mid-90s. Imagine if Robert, seeing the divorce was going south, decided to take a $50,000 loan from his 401k to pay for his new apartment and legal fees. Since it was a loan against his own assets, he felt entitled to it. However, when the court finally ordered the split of the 401k, the total value had been depleted. The law in many states was still catching up to whether a 401k loan constituted a dissipation of marital assets. In many case studies from 1998, the non-participant spouse ended up with half of a depleted account, plus a legal bill to fight for a shadow asset that no longer existed. Then there was the issue of the lost decade of inflation and the hidden costs of the 401k versus the IRA. When a spouse received their share via a QDRO, they usually had two choices: keep the money in the existing employer's plan in a separate account or roll it over into an individual retirement account. In the 1990s, the fees associated with 401ks were often opaque and significantly higher than they are in 2026. A spouse might think they were getting $100,000, but if they stayed in the employer plan, they might be paying 2% in administrative and management fees annually. Over a decade, that could eat nearly a quarter of their potential outcomes compared to a low-cost IRA. Furthermore, we must examine the survivorship trap. This is perhaps the most tragic element of 1990s 401k history. If a QDRO was drafted but not yet qualified by the plan administrator, and the participant spouse suddenly passed away, the money did not necessarily go to the ex-spouse. Under ERISA law, the 401k typically goes to the named beneficiary on the plan. If the participant had remarried or never changed the beneficiary from their mother or sibling, the ex-spouse could find themselves completely disinherited despite having a signed divorce decree in their hand. The federal law of ERISA almost always trumped state divorce law. This meant that in the 90s, the race to the plan administrator was a literal matter of life and death for a person's financial future. To add even more complexity, the 1990s was the era of the mega-merger. Think of the massive corporate consolidations like Exxon and Mobil or Travelers and Citicorp. When these companies merged, their 401k plans merged too. For someone in the middle of a divorce, this was a nightmare. Your QDRO might have been perfectly drafted for the old plan, but by the time it was submitted, the new plan had different rules, a different administrator, and different investment options. The paperwork would be sent back as unprocessable, forcing the legal teams to start from scratch while the meter on their hourly fees continued to run. We also have to look at the psychological warfare of the 401k in 90s divorce. Because the 401k was often the only source of liquid cash besides a home, it became a leverage tool. One spouse would threaten to quit their job or retire early to trigger a payout or change the vesting schedule. Vesting was a major point of contention. If a spouse had $100,000 in their account but was only 60% vested, the unvested $40,000 was a phantom asset. Courts struggled with how to value something that might never exist. If the employee's spouse stayed at the job, that money would become real. If they left the day after the divorce, that money vanished. How do you compensate a spouse for 50% of a phantom? The step-by-step reality of a 1990s 401k split looked like this. First, the discovery phase, where one spouse had to legally compel the other to hand over paper statements that were often lost. Second, the valuation phase, where an actuary might be hired to determine the coverture fraction, the ratio of time married while in the plan versus the total time in the plan. Third, the drafting of the QDRO, which required a specialized specialist because regular divorce lawyers were prone to errors. Fourth, the submission to the plan administrator, followed by a mandatory waiting period that could last months. Finally, the segregation of assets, where the money was finally moved into a separate subaccount. This entire process was a gauntlet. And yet, even if you survived the gauntlet, you still had to face the IRS. The 1990s saw a rise in Section 72T distributions. This allowed a non-employee spouse who received money via a QDRO to take a cash distribution without the 10% penalty, even if they were under 59 and a half. For many women in the 90s who had been out of the workforce, this was a lifeline. It allowed them to buy a house or pay for retraining. But it was a double-edged sword. Every dollar taken out was a dollar that wouldn't grow during the upcoming tech boom. They were trading their 70s for their 40s, a decision that many are regretting now in the mid-2020s. As we look deeper into this history, we begin to see a pattern. The 401k wasn't just a savings account. It was a weaponized financial instrument that rewarded the person with the best records and the most aggressive legal team. But what happened when the plan itself failed? Or what happened when the company stock that made up the 401k, think Enron or WorldCom as we move toward the end of the decade, suddenly went to zero right as the QDRO was being signed? The stakes only get higher from here. In the next part, we are going to look at the dark side of company stock and how the obsession with owning where you work created a trap that no QDRO could fix. we will examine the specific case of the paper millionaires, who ended up in poverty because they split an asset that was built on a foundation of sand. You will see why the 1990s buy and hold mantra became a hold and die reality for those who didn't understand the liquidity trap. Stay tuned because the intersection of the 1999 market peak and the 1999 divorce rate created a perfect storm that changed American wealth forever. The perfect storm of 1999 was not just about the numbers on a balance sheet, it was about the dangerous illusion of permanent prosperity. By the late 90s, the 401k had transformed from a supplemental retirement tool into a cultural obsession. In the United States, the S&P 500 had seen years of double-digit returns, and the Nasdaq was climbing at a rate that defied historical trends. For a couple like Mark and Linda in suburban Virginia, their 401k was no longer a boring fund managed by a distant trustee. It was a portfolio of high-flying tech stocks like Lucent, Sun Microsystems, and Dell. When they decided to part ways in early 1999, they were looking at a combined 401k valuation of nearly $1.2 million. To Mark and Linda, this $1.2 million felt like cash in the bank. They made the classic 1990s mistake. They treated a volatile equity asset as if it were a stable currency. This is what we call the liquidity trap of the late 90s. Imagine if Mark decided he wanted to keep the entire 401k because he believed the tech boom would continue forever, and in exchange he gave Linda the family home and their liquid savings. He was essentially betting his entire future on the idea that the 401k's paper value was its real value. But a 401k in 1999 was often heavily concentrated in company stock. Many large U.S. employers encouraged or even mandated that their matching contributions be held in the company's own shares. This created a concentration risk that the divorce courts of the 1990s were ill-equipped to handle. If Mark's 401k was 70% invested in his employer's stock, and that company was one of the many dot-com-era darlings, the valuation on the day of the divorce filing was a fantasy. In many case studies from 1999, we see the devastating aftermath of these lopsided settlements. By the time the tech bubble burst in 2000 and 2001, the spouse who kept the 401k saw their million-dollar settlement evaporate into $200,000, while the spouse who took the house or the cash walked away with their net worth intact. The step-by-step failure of these settlements often began with the lack of a market adjustment clause in the QDRO. In 1999, a poorly drafted QDRO might award a spouse a flat dollar amount, rather than a percentage. Imagine Linda was awarded exactly $600,000 from Mark's account. If the market crashed before the plan administrator processed the transfer, Mark would be legally obligated to pay Linda $600,000, even if the total account value dropped to $500,000. He would be left with zero, or worse, he would be in contempt of court for a debt he could no longer pay. This historical trend led to a massive wave of post-decree modifications as the market turned, clogging the court systems for years. Then we have the tax ghost of 1999. In the heat of the tech boom, people were so focused on the total number that they ignored the embedded tax liability. A dollar in a 401k was not worth a dollar in a checking account. If Mark and Linda were splitting that $1.2 million, they were actually splitting about $800,000 in after-tax purchasing power. However, if Linda took her share and immediately used a portion of it for a down payment on a new home, utilizing the QDRO distribution exception, she would be hit with ordinary income tax on that withdrawal. In 1999, with high tax brackets, a $100,000 withdrawal could result in a $35,000 tax bill. Many divorcees in the late 90s found themselves in a tax spiral, where they had to withdraw even more money from their 401k just to pay the taxes on their first withdrawal, rapidly depleting their principal during a market downturn. Another critical factor in 1999 was the rise of the self-directed 401k. For the first time, average employees had the power to trade stocks within their retirement plans. This introduced the concept of investment misconduct into divorce proceedings. Imagine if Mark, sensing the divorce was imminent, moved the entire 401k into extremely high-risk penny stocks or speculative tech options as a way to gamble for a massive gain, or conversely, to burn the house down so Linda would get nothing. In the 90s, proving intentional dissipation of a 401k was incredibly difficult. The courts often viewed investment losses as the luck of the market, rather than a deliberate attempt to reduce the marital estate. This allowed for a form of financial sabotage that left many non-participant spouses with pennies on the dollar. We must also look at the vesting cliff. In 1999, Many tech companies used aggressive vesting schedules to keep employees from jumping to competitors. A worker might have a massive 401k balance, but if they hadn't reached their 5-year mark, the employer match portion wasn't legally theirs yet. In a 1999 divorce case study, the question of future interest became paramount. If the husband was set to vest in $200,000 worth of stock in 6 months, was the wife entitled to half of that? The 90s courts were divided. Some argued it was separate property because it hadn't been earned yet. Others argued it was marital property because the work that earned the vesting happened during the marriage. This uncertainty led to golden handcuff settlements, where couples were forced to stay legally connected for years after their divorce just to wait for a vesting date. The 1990s also saw the beginning of the fee war. Plan participants began to realize that their 401ks were being eroded by mutual fund loads and 12b1 fees. In a divorce settlement, if one spouse was rolling their money into a high-fee retail IRA, while the other stayed in a low-fee institutional 401k, the long-term potential outcomes were vastly different. A difference of 1.5% in annual fees could result in one spouse having hundreds of thousands of dollars less over a 20-year period. In 2026, we look back at these 1999 settlements and see a massive wealth gap created purely by the choice of the rollover vehicle. Consider the case of the paper millionaire in 1999. An executive at a company like Enron or WorldCom might have a 401k worth $2 million, almost entirely in company stock. During the divorce, they might agree to give their spouse $1 million in other assets like the house, the cars, and the brokerage account to keep the 401k intact. They believed they were being smart by keeping the growth engine. When those companies collapsed shortly after the turn of the millennium, the executive was left with a 401k worth zero, while the ex-spouse held the tangible assets. This reverse alimony scenario, where the supposedly wealthier spouse ended up destitute, was a direct byproduct of the 1999 valuation mania. The step-by-step breakdown of a 1999 401k split also had to account for dividend reinvestment. In the late 90s, many 401ks were set to automatically reinvest dividends. If a QDRO was signed in June but not executed until December, those 6 months of dividends and the reinvested shares became a point of bitter contention. Was the alternate payee entitled to the shares purchased with dividends during the waiting period? Without explicit language in the QDRO, the plan administrator would often default to the participant, leading to more hidden wealth transfers that total billions across the American economy. As we conclude this look into the 1999 peak, we see that the 401k divorce was not a simple math problem. It was a high-stakes poker game played with shifting rules, and a deck that was often stacked against the person who didn't hold the password to the account. But the 1990s were just the beginning. The systems built in this era were about to be tested by the first true crash of the 401k age. What happened when the unqualified orders of the 90s met the market meltdown of the early 2000s? We are going to dive into the specific legal disasters where spouses were ordered to pay money that no longer existed. We will examine the QDRO malpractice wave that saw a generation of divorce lawyers sued for failing to understand the math of the 401k. And most importantly, we will look at the Social Security offset myths that led thousands of people to miscalculate their retirement needs during the most vulnerable transition of their lives. The 401k was designed for savings, but in the hands of a divorce court, it became a wrecking ball. Stay with us for Part 4, where we uncover the lost QDROs and the fight for the remnants of the American dream. The fight for the remnants of the American dream in the late 1990s often came down to a single terrifying phenomenon: the lost QDRO. To understand this, you have to realize that in 1998, the legal infrastructure for processing domestic relations orders was essentially a manual assembly line prone to catastrophic human error. Imagine a woman named Diane in Chicago. After a grueling 2-year divorce battle with her husband, a high-earning software executive, she was awarded 50% of his 401k, valued at the time at $800,000. Her attorney drafted the paperwork, the judge signed it, and Diane walked away believing the ordeal was over. But here is the structural flaw of that era. Simply having a judge sign a divorce decree did not move the money. The decree had to be converted into a very specific legal instrument called a qualified domestic relations order, which then had to be physically mailed to the plan administrator at her ex-husband's corporation. In Diane's case, her lawyer filed the decree but never followed through on the actual qualification process with the plan. This created a legal ghost. On the court's books, the money belonged to Diane, On the 401k plan's books, it still belonged entirely to her ex-husband. This leads us to the historical trend of the QDRO malpractice wave. In the late 90s, many general practice attorneys treated 401ks like simple bank accounts. They didn't realize that under the Employee Retirement Income Security Act, or ERISA, a plan administrator has the absolute right to reject a court order if it doesn't meet the plan's specific summary plan description. While Diane was moving on with her life, her ex-husband decided to retire early and take a lump sum distribution of his entire account. Because there was no qualified order on file to freeze the funds, the company cut him a check for the full $800,000. By the time Diane realized the money was gone, her ex-husband had moved the funds into an offshore account or spent them on non-traceable assets. Diane was left with a piece of paper signed by a judge that was worth nothing because the asset it described had been legally liquidated. The step-by-step failure in these scenarios usually followed a predictable path of administrative negligence. First, the attorney would fail to send a joinder to the plan. A joinder is a legal action that joins the retirement plan as a party to the divorce, effectively putting the plan administrator on notice that a claim is pending. Without this, the plan administrator has no legal obligation to stop the participant from withdrawing funds, taking a loan, or changing beneficiaries. In the 90s, many lawyers skipped this step to save on filing fees or out of sheer ignorance of federal pension law. Second, the delay in drafting the QDRO was often lethal. In a high-speed market like 1999, the value of a 401k could change by 10% in a single week. If the lawyer waited 3 months to draft the QDRO, the valuation specified in the divorce decree might no longer match the reality of the account. This created a scenario where the plan administrator would reject the order because the math didn't add up. We saw case studies where a QDRO was rejected 5 or 6 times over a 2-year period, each time requiring a new court appearance and more legal fees, while the underlying assets were being eroded by market volatility or hidden withdrawals. This brings us to the Social Security offset myth, a specific piece of misinformation that plagued 1990s divorce negotiations. Many people believe that if one spouse had a large 401k and the other had a solid Social Security history, the court would automatically balance the two. But 401ks are private property, and Social Security is a federal entitlement. In the 90s, some states allowed for a Social Security offset calculation, while others strictly prohibited it. Imagine a husband who worked in a private sector job with a 401k, and a wife who worked as a teacher in a state where she didn't pay into Social Security, but had a government pension. The complexity of comparing a 401k's cash value to a government pension's lifetime monthly benefit led to thousands of lopsided settlements. People were essentially trying to trade oranges for future hypothetical apples. Furthermore, we must examine the 10% penalty trap that caught so many people off guard in 1997 and 1998. Under Internal Revenue Code Section 72T(2)(c), payments made to an alternate payee under a QDRO are exempt from the 10% early withdrawal penalty. However, this only applies if the money is taken directly from the 401k. In many case studies, we found that a spouse would receive their 401k share, roll it over into their own individual retirement account, IRA, and then withdraw money from the IRA to pay for their post-divorce living expenses. The moment that money touched the IRA, it lost its QDRO protection. By moving the money to an IRA first, the spouse accidentally triggered the 10% penalty they were trying to avoid. In 1998, a $50,000 withdrawal for a down payment on a house could suddenly cost an extra $5,000 in penalties plus ordinary income tax, simply because of the order in which the paperwork was handled. The depth of this crisis extended into the very definition of what counted as a 401k. In the 90s, we saw the rise of the 403b for nonprofits and the 457 for government workers. While they functioned similarly to a 401k, the rules for splitting them were different. A lawyer using a standard 401k QDRO template for a 457 plan would almost certainly have the document rejected. The 457 plans, in particular, had different rules regarding when an alternate payee could access the money. Some plans wouldn't allow the ex-spouse to touch the funds until the participant reached retirement age, even if the divorce happened 20 years earlier. Imagine being 40 years old, newly single, and being told that your primary asset is locked in a vault for the next quarter century. This created a generation of asset-rich but cash-poor divorcees who had no way to fund their transition to a new life. We also have to discuss the anti-alienation provisions of ERISA. These were designed to protect workers' retirements from creditors, But in the 90s, they were often used as a shield by uncooperative spouses. A participant could argue that their 401k was untouchable, leading to protracted legal battles that would exhaust the marital estate before a single dollar was ever divided. The only way around this was the QDRO, but as we've seen, the QDRO was a fragile instrument. As the decade drew to a close, the 401k divorce became a symbol of the complexity of modern American life. It was no longer just about who got the dog or the minivan. It was a sophisticated game of tax chess where a single wrong move could result in a 40% loss of net worth. The lessons of the 90s taught us that the person with the most documentation usually won. If you had the summary plan description, the joinder, the properly drafted QDRO, and the tax-conscious distribution strategy, you could survive. If you relied on a standard divorce attorney, you were likely headed for a financial crash. But what happened when the crash wasn't just a metaphor? As we transition into the final years of the 1990s, the Enron era was looming. We are going to look at the nightmare of unvested options, and how the pursuit of imaginary wealth led to the most expensive legal mistakes in history. What happens to a divorce settlement when the 401k is entirely invested in a company that is being investigated by the SEC? How did the 1990s tech wreck fundamentally change the way judges look at 401k valuations today in 2026? The answers lie in the ruins of some of the biggest corporate collapses in history, and the families that were caught in the middle. Stay tuned for Part 5, where we explore the shadow assets that turned millionaires into debtors overnight. The transition into the late 1990s brought about the era of shadow assets, a period where the perceived wealth in a 401k often bore no resemblance to its actual utility or future value. To understand this, we have to look at the explosion of employee stock options and restricted stock units that were frequently housed alongside or within the retirement framework of major U.S. corporations. Consider a character named David, a mid-level executive at a telecommunications giant in 1999. His 401k statement showed a balance of $1.5 million. During his divorce from his wife, Jennifer, this $1.5 million was the centerpiece of the negotiation. Jennifer, looking at the historical trends of the market, agreed to waive her right to the family's real estate and liquid savings in exchange for 60% of that 401k. However, David's 401k was an Enron-style trap. It was almost entirely composed of company stock that David was restricted from selling due to his executive level or the specific plan rules of the time. In 1999, many companies utilized a forced match system where the employer's contribution was exclusively in company shares, and employees were often barred from diversifying those shares until they reached age 50 or 55. This created a scenario where Jennifer was effectively being awarded $900,000 worth of a single company's future. When that company collapsed under the weight of accounting scandals and the bursting of the tech bubble, Jennifer's 401k share didn't just lose value, it ceased to exist. This specific historical trend highlights the valuation fallacy of the 1990s. In 2026, we have sophisticated tools to stress test a portfolio during a divorce, but in the 90s, the court usually looked at a single snapshot in time, the date of trial or the date of separation. If the stock was trading at $90 a share on that date, the court treated it as $90 in cash. There was no discount applied for lack of marketability or the risk of concentration. Jennifer became a debtor to her own future because she had traded tangible, diversified assets for a concentrated shadow asset that had no floor. The step-by-step destruction of wealth in these cases often involved the interplay between the 401k and the alternative minimum tax, or AMT. In the late 90s, if a 401k split involved the exercise of certain types of stock options that were tied to the retirement package, the tax implications could be astronomical. Imagine a scenario where David exercised options to fund the cash portion of Jennifer's settlement. The paper gain on those options could trigger a massive AMT bill. In some documented case studies, the tax bill was actually higher than the cash realized from the sale because the stock price plummeted after the exercise but before the tax was due. This created a situation where the participant spouse owed the IRS money they no longer had, while the non-participant spouse held a QDRO for an account that was rapidly deflating. We also have to examine the concept of the double dip in 1990s legal theory. This occurred when a court would count a 401k as an asset to be divided, and then also count the future distributions from that same 401k as income for the purposes of calculating alimony or spousal support. For an older worker getting divorced in 1998, this was a mathematical impossibility. If you give away half the pile, you cannot generate the same level of income that the full pile would have produced. Yet, many settlements were signed that obligated the high earner to pay alimony based on a 401k funded lifestyle that they could no longer afford after the split. This led to a wave of bankruptcies in the early 2000s as the first generation of 401k reliant retirees realized their court-ordered obligations were based on a market peak that had vanished. Another shadow asset that caused chaos was the unvested employer contribution. In 1999, many companies had 5-year or even 7-year vesting cliffs. If David had been at his company for 4 years, his statement might show $500,000 in employer matches, but his legal ownership of that money was 0%. In the 90s, the legal question was, is this a marital asset? If the marriage lasted 10 years, but the vesting required another year of work post-divorce, Jennifer's lawyer would argue that the work performed during the marriage earned that money. David's lawyer would argue that the money didn't exist yet. The compromise often involved a deferred QDRO, where the plan administrator was told to split the money only if and when it vested. But if David was laid off in the 2001 recession before that vesting date, the asset disappeared for both of them, leaving Jennifer with nothing and David with the legal fees for a fight over a ghost. This era also saw the rise of the Qualified Medical Child Support Order, or QMCSO, which often competed with the 401k for priority. In the 90s, as healthcare costs began to climb, some courts began to look at the 401k as a backstop for medical expenses. If a divorce decree mandated that a parent provide health insurance, and that parent lost their job, some creative lawyers attempted to attach the 401k to pay for those premiums. This was a direct violation of ERISA's anti-alienation rules, yet it happened frequently enough to cause massive administrative delays. A 401k could be frozen for years while the plan administrator, the state court, and the Federal Department of Labor argued over who had the right to the money. During this freeze, the participants could not move their money out of the failing tech stocks, effectively forcing them to ride the ship all the way to the bottom. Furthermore, we must address the 1990s obsession with borrowed lifestyle. Because 401k balances were so high, many couples felt comfortable taking on massive debt, McMansions, luxury SUVs, and private school tuitions, believing the 401k was their safety net. When the divorce happened, they realized that the 401k was the only thing they could use to pay off that debt. But using a 401k to pay off a mortgage or a credit card in 1999 meant taking a distribution. After the 20% federal withholding and the 10% penalty, a couple would have to withdraw $150,000 just to pay off $100,000 in debt. This 33% haircut on the family's net worth was the price of liquidity in the 90s. The complexity reached its zenith with the 401k loan. In the 90s, 401k loans were often used to fund the very lifestyle that led to the marriage's strain. If David had a $50,000 outstanding loan on his 401k at the time of the divorce, that loan was considered an asset of the marriage because the cash had been spent on marital things. However, if the QDRO ordered that 50% of the account be moved to Jennifer, the plan administrator would often treat the $50,000 loan as a distribution to David. This would trigger an immediate tax bill and penalty for David, essentially punishing him for a loan that the couple had used together. As we look at these case studies, a terrifying reality emerges. The 401k was never designed to be a divisible asset in a high-stakes legal battle. It was designed for a single worker to hold until age 65. The 1990s was the first time we tried to use it for something else, and the results were often catastrophic. The shadow assets, the tax traps, and the administrative failures turned the 401k from a dream into a nightmare for a significant portion of the U.S. population. But as the 90s ended and the 2000s began, a new threat emerged. It wasn't just about how to split the 401k. It was about whether the 401k would even be there. We are moving into the era of the corporate raiders and the Pension Benefit Guaranty Corporation. What happens when the company you work for is bought by a competitor who terminates the 401k plan entirely in the middle of your divorce? How does a QDRO function when there is no plan left to qualify? And what are the secret strategies that savvy investors used in 1999 to shield their retirement from their spouses that are now being used again in 2026? The next part of our deep dive will expose the hidden world of offshore IRAs and the 1990s retirement shield that left thousands of spouses in the dark. You won't want to miss the revelations about the missing millions as we move into part 6. The transition into the year 2000 was marked by a desperate search for security as the tech-heavy 401ks of the late 1990s began to show their first cracks. However, for a specific subset of high net worth individuals in the United States, the strategy was not about diversification, it was about the retirement shield. This was a sophisticated, often legally gray movement where 401k assets were manipulated or moved into specialized vehicles to keep them out of the reach of a divorcing spouse. To understand this, we need to look at the case study of a corporate executive we will call Michael, who in 1999 presided over a retirement portfolio worth $3 million. Michael was aware that his marriage was failing, and he knew that a standard qualified domestic relations order would likely result in him losing half of his life's work. In the late 90s, the retirement shield often involved the use of the offshore IRA, or the self-directed retirement trust. While the 401k itself is a creature of federal law and must stay within the U.S. employer system, Michael utilized a specific historical loophole. He took a permitted distribution or a massive 401k loan, permitted because of his high seniority and plan-specific rules, and rolled those funds into a specialized self-directed IRA. From there, the IRA invested in offshore entities or private shell companies that were nearly impossible for a domestic divorce attorney to value or track. This created the phenomenon of the missing millions. When Michael's wife Karen filed for divorce in early 2000, the discovery phase of the legal battle was a nightmare. Michael's 401k statement showed a significantly reduced balance. When Karen's legal team questioned where the money went, Michael pointed to the market downturn and the unfortunate performance of his self-directed investments. In the 1990s, court-appointed forensic accountants were often ill-equipped to pierce the veil of these complex retirement trusts. The historical trend was clear. If you could obfuscate the trail of the 401k money for just 18 months, the spouse would often settle for a fraction of the value just to end the litigation. The step-by-step mechanics of this shield often relied on the in-service distribution. Most people think you can't touch your 401k while you are still working, but in the 90s, many executive-level plans allowed for these distributions once an employee reached age 59 and a half, or sometimes even earlier for hardship or diversification reasons. Michael triggered an in-service distribution, moved the money to a brokerage account, and then funneled it into a series of limited partnerships. By the time the QDRO was drafted, there was no 401k left to divide. The asset had been alienated in a way that bypassed the traditional protections of the family court. Furthermore, we must examine the corporate raider impact on 401k divorces. In the late 90s, the U.S. was in a frenzy of mergers and acquisitions. Imagine if the company Michael worked for was suddenly bought out by a larger conglomerate. The new company would often terminate the old 401k plan and enroll everyone into a new system. For Karen, who was mid-divorce, this was a catastrophe. The plan she had joined via her legal team no longer existed. The new plan administrator had no record of her claim. This administrative void allowed Michael a window to change his beneficiary designations, or even liquidate his position before the new legal paperwork could be filed. In 2026, we see this as a form of systemic financial abuse, but in 1999, it was often just viewed as a messy consequence of corporate restructuring. This leads us to the valuation of the small business 401k. While big corporate plans had some oversight, the 401ks of small to mid-sized American businesses in the 90s were often treated as personal piggy banks by the owners. If a husband and wife ran a business together and the husband was the sole trustee of the 401k, he could essentially loan the 401k money back to the business to pay for operational expenses that were actually personal luxuries. By the time of the divorce, the 401k was nothing but a stack of promissory notes from a business that was intentionally being run into the ground. The non-participant spouse was left with 50% of a debt rather than 50% of a retirement fund. The role of the QDRO mill also began to emerge in the late 90s. These were high-volume, low-cost legal services that promised to churn out QDROs for a flat fee. However, because they didn't understand the nuances of the 1997 Taxpayer Relief Act or the specific, separate interest rules of different plan providers, they often produced flawed documents. A common historical trend was the inadvertent distribution error. The QDRO would be written in a way that caused the plan administrator to cut a check directly to the ex-spouse instead of performing a direct rollover to an IRA. This triggered immediate mandatory 20% federal withholding. For a spouse like Karen, receiving $500,000, she would suddenly find $100,000 missing before the check even cleared her bank. The potential outcomes for these errors were almost always negative, leading to a secondary market of litigation against the very lawyers who were supposed to be protecting the assets. Another layer of the shield was the premarital credit manipulation. In 1999, calculating the premarital portion of a 401k required historical data that many plan administrators simply didn't keep for more than 7 years. Michael could claim that $500,000 of his 401k was from his pre-marriage years, and without the paper trail to disprove him, the court would often take his word for it. This shadow credit allowed participant spouses to carve out huge sections of the account as separate property, even if the vast majority of the growth had occurred during the marriage. We also have to discuss the death of the pension and the rise of the cash balance plan. In the late 90s, many traditional pensions were being converted into cash balance plans, which looked and felt like 401ks but had different legal protections. During a divorce, the valuation of a cash balance plan was far more complex than a 401k. It required an actuary to determine the present value of a future benefit. Many spouses in the 90s accepted a cash value settlement based on what the statement said today, not realizing that the true value was 3 times higher if they had waited for the annuity to kick in. They were essentially being bought out of their retirement for pennies on the dollar because they didn't understand the math of the conversion. The psychological toll of the retirement shield was immense. It turned the 401k from a symbol of a shared future into a tool of control and punishment. By the year 2000, the gender wealth gap in divorce was being driven largely by who held the 401k and who knew how to hide it. As the market began its long slide after the dot-com peak, the battle for these assets became even more vicious. Spouses who had been promised a certain lifestyle were finding that the millions they were fighting over were either gone, hidden, or tied up in companies that were being delisted from the stock exchange. But the story doesn't end with hidden accounts. As we look toward the next chapter, we have to face the most controversial aspect of 401k history: the bankruptcy protection loophole. In the 90s, your 401k was one of the only things a bankruptcy court couldn't touch. This led to a scandalous trend where individuals would intentionally file for bankruptcy during their divorce to discharge their debts and their obligations to their ex-spouse, all while keeping their million-dollar 401k completely intact. How did the U.S. Supreme Court eventually rule on this? What happened when the 401k became a get-out-of-divorce-free card for the wealthy? And how did the 2001 Enron collapse finally force Congress to change the rules of the game? In Part 7, we are going to dive into the bankruptcy shield and the legal battles that reached the highest courts in the land, revealing how the 401k became the ultimate fortress for the elite. The line between protection and fraud was about to be blurred forever. Stay tuned for the deep dive into the 401k bankruptcy wars. The 401k bankruptcy wars of the late 1990s and early 2000s represented one of the most significant legal contradictions in American history. It was a period where the federal government's desire to protect retirement savings collided head-on with the state court's desire to ensure equitable distribution during a divorce. To understand the gravity of this, imagine a high-earning surgeon named Thomas in 2000. Thomas had a 401k valued at $2.2 million. He also had a mountain of marital debt, including a massive mortgage, lines of credit used to fund a lavish lifestyle, and significant legal fees from a contentious divorce with his wife, Susan. Thomas realized a startling reality about the laws of that era. Under the Employee Retirement Income Security Act, or ERISA, assets held within a qualified 401k were generally considered spendthrift trusts, meaning they were protected from the claims of creditors. In a move that became a notorious historical trend, Thomas filed for Chapter 7 bankruptcy in the middle of his divorce proceedings. Because of the federal protections afforded to 401ks, his $2.2 million remained entirely shielded from the bankruptcy court. However, his obligation to pay out a cash settlement to Susan for her share of the equity in their home and other non-retirement assets was suddenly on the chopping block. In many case studies from this period, we saw the 401k become a fortress for the participant spouse. While the bankruptcy court could discharge general debts, the question of whether it could discharge a property settlement debt owed to an ex-spouse was the subject of fierce litigation. Before the law was clarified, some individuals successfully used bankruptcy to wipe out the money they owed their former partners, all while walking away with a fully intact million-dollar 401k. For Susan, the potential outcomes were devastating. She watched as the marital debt was wiped clean, but the liquid assets she was counted on were vanished by the bankruptcy filing, leaving her ex-husband wealthy and her essentially bankrupt by association. The step-by-step tactical use of this loophole involved a specific sequence of filings. First, the participant would delay the signing of the QDRO. As we have established, until that QDRO is qualified, the money is legally the property of the participant. Second, the participant would file for bankruptcy. Third, they would list the divorce settlement as an unsecured debt. This created a race against time. If the non-participant spouse didn't get their QDRO qualified before the bankruptcy discharge, they could be reduced to the status of a common creditor, like a credit card company or a medical biller. In the 1990s, this was a gap in the law large enough to drive a truck through. This brings us to the landmark legal shifts that began to emerge in the wake of such perceived injustices. The U.S. public began to see that the 401k was being used as a weapon of financial attrition. However, the 401k fortress had another weakness: the 1990s tech wreck and the specific catastrophe of company stock. To understand the shift from bankruptcy protection to total loss, we must look at the employees of companies like Enron or WorldCom. Imagine if Susan had finally won her battle and received a QDRO for 50% of Thomas's 401k, but that 401k was entirely invested in Enron stock. In late 2001, as the company's fraudulent accounting was exposed, the stock price plummeted from nearly $90 to less than $1 in a matter of months. This created a new kind of 401k divorce crisis. The court had ordered a division based on a value that no longer existed. This was not a bankruptcy shield. It was a total wipeout. The historical trend in these cases saw spouses who had fought for years for their fair share, ending up with a 401k balance that couldn't cover the cost of the paper it was printed on. The step-by-step collapse of these Enron-style 401k settlements revealed a massive flaw in the 1990s buy-and-hold philosophy. Many plan participants were actually locked out of selling their company stock during the very window the company was collapsing, a period known as a blackout. If a divorce was finalized during a blackout period, the assets were frozen in a falling knife. The legal system had no mechanism to compensate the non-participant spouse for this systemic failure. The court's attitude was often that both parties shared in the investment risk of the marriage, even if only one party had the insider knowledge that the company was in trouble. We also have to analyze the cash-out phenomenon of the late 90s. As the market peaked, many people getting divorced decided to simply cash out their 401k and take the tax hit rather than deal with the complexity of a QDRO. In 1999, the U.S. saw a spike in early withdrawals. Couples would say, "Let's just split the cash and go our separate ways." This was a short-term solution with long-term catastrophic consequences. By cashing out at the top of the market and paying 30 to 40% in taxes and penalties, they were destroying the power of compound interest. In 2026, we look back at those decisions and see that a $100,000 cash out in 1999 resulted in the loss of nearly $1 million in potential growth by retirement age. Furthermore, the 1990s introduced the Qualified Domestic Relations Order as a lien. In some states, savvy lawyers began to record the QDRO against the 401k plan as soon as the divorce was filed, rather than waiting for the final decree. This was an attempt to prevent the bankruptcy shield from working. If the lien was in place, the 401k was already partially owned by the ex-spouse before the bankruptcy was filed. This led to a patchwork of state-level rulings that made 401k divorces in California look completely different from those in New York or Texas. The complexity of these bankruptcy shields and market wipeouts led to the eventual passage of the Bankruptcy Abuse Prevention and Consumer Protection Act later on, but for the people of the 1990s, the damage was already done. They were the beta testers for a retirement system that was never intended to be the primary asset in a divorce. They were caught between federal ERISA laws that protected the worker and state domestic relations laws that tried to protect the family. The role of the 401k loan as a bankruptcy tool also deserves depth. In the 90s, a participant could take a maximum loan from their 401k right before filing for divorce or bankruptcy. They would then use that cash for non-traceable expenses. Since a 401k loan is essentially you borrowing from yourself, it didn't create a third-party debt that the bankruptcy court could easily scrutinize. This was a double dip of the worst kind. The participant got the cash, the 401k balance was reduced for the purposes of the divorce split, and the participant would slowly repay themselves with pre-tax dollars after the divorce was over, effectively rebuilding their wealth while their ex-spouse was left with a diminished share. As we move toward the final parts of this masterclass, we have to address the legacy of the 90s. How did these battles over bankruptcy and company stock change the way 401ks are structured today? Why do modern plans have diversification requirements, And why are QDROs now often processed electronically in weeks instead of months? The answers lie in the thousands of lives that were financially upended during the 1990s. But there is one final darker corner of the 401k divorce that we haven't touched: the named beneficiary versus the QDRO. What happens if the paperwork is perfect, the bankruptcy is avoided, and the market is stable, but the participant dies the day before the money is moved? In Part 8, we explore the sudden death trap and the federal law that allows 401k plans to ignore your will and your divorce decree entirely. This is the part of the story where the contract beats the court, and it is the most terrifying open loop in the entire history of American retirement. Stay tuned for the death of the decree. The death of the decree is perhaps the most harrowing chapter in the history of 1990s 401k litigation, because it highlights the absolute supremacy of federal contract law over state family court orders. In the United States during the late 90s, a divorce decree signed by a state judge was often viewed by the public as the final word. However, for a 401k, the final word was not held by a judge, but by a piece of paper sitting in an HR file, the beneficiary designation form. To understand how this created a financial graveyard, let's look at a case study of a woman named Maria. Maria and her husband, James, divorced in 1996 after 22 years of marriage. The court awarded Maria 50% of James's 401k, which was worth approximately $600,000 at the time. The divorce decree was final, and the judge had explicitly stated that Maria was the owner of half that account. But James, either through negligence or spite, never updated his beneficiary form at work, and Maria's lawyer was slow to finalize the formal qualified domestic relations order. 3 months after the divorce, James suddenly passed away from a heart attack. Maria went to the 401k plan administrator to claim her $300,000. Instead, she was told that the entire $600,000 was being paid out to James's sister, who had been named as the beneficiary in 1984 and was never removed. Maria sued, pointing to her divorce decree. The case went all the way up the legal chain, and the outcome reflected a brutal historical trend. Under the ERISA principle of plan documents rule, the plan administrator is legally obligated to pay the person named on the form, regardless of what a state divorce decree says. The decree was effectively dead. This scenario happened thousands of times in the 90s because of the disconnect between state and federal law. In 2026, we look back at this as a systemic failure of the paperwork chain. Step by step, the failure occurred because Maria's interest was not yet qualified. In the eyes of federal law, until that QDRO is accepted by the plan, the non-employee spouse has no legal standing. This created a dangerous window of time, often months or even years, where the participant spouse held all the power. If the participant died, became incapacitated, or even just quit their job and took a payout before the QDRO was qualified, the ex-spouse's rights could vanish instantly. The depth of this issue extended to the 1990s trend of the second marriage trap. Imagine James hadn't died, but instead remarried a woman named Linda just weeks after his divorce from Maria was finalized. Under federal law, a new spouse automatically gains certain rights to a 401k. If James died before Maria's QDRO was qualified, the new wife, Linda, would often have a superior legal claim to the retirement funds than the ex-wife Maria, despite Maria's 22 years of marriage. This created a race to the altar, and a race to the courthouse, that turned 401k assets into a source of inter-family warfare. We also have to examine the 1990s anti-lapse statutes that many states tried to pass to prevent this. These state laws said that a divorce automatically revokes a spouse's status as a beneficiary. But in a series of landmark cases throughout the decade, the Supreme Court of the United States made it clear: ERISA preempts state law. This meant that even if a state law said the ex-spouse was no longer the beneficiary, the federal law said the plan document was the only thing that mattered. This created a federal fortress around the 401k that made it nearly impossible for a wronged spouse to recover funds once they were paid out to the wrong person. The step-by-step reality for a 1990s divorcee was a desperate need for a restraining order, specifically aimed at the 401k plan itself. Savvy attorneys began to realize that they needed to serve the plan administrator with a notice of adverse interest the moment a divorce was filed. This was a historical shift in legal strategy. It wasn't enough to fight the spouse, you had to fight the plan's administrative inertia. If the plan administrator received this notice, they might place a temporary administrative hold on the account, preventing loans or distributions while the QDRO was being drafted. However, not all plans honored these holds in the 90s, and many spouses found their accounts liquidated before the hold was even processed. Another hidden trap was the in-kind distribution versus cash liquidation. In the late 90s, during the peak of the dot-com boom, many 401ks were held in specific mutual funds or company stocks that the participant didn't want to sell. If a QDRO ordered a split, the plan administrator often had to liquidate half the shares to move the cash into a new account for the ex-spouse. This liquidation often happened on a random Tuesday, regardless of whether the market was up or down. A spouse could lose 5% of their settlement value in a single day simply because of the timing of the sell order by a faceless bureaucrat in an HR department 3 states away. Furthermore, we must address the survivor benefit crisis. In the 90s, many QDROs were drafted without a survivor benefit clause. This meant that if the participant's spouse died after the divorce but before the ex-spouse started taking distributions, the ex-spouse share would revert back to the plan or go to the participant's new family. To prevent this, the QDRO had to specifically name the ex-spouse as the surviving spouse for the purposes of the plan. This was a piece of high-level legal engineering that many 1990s lawyers simply missed. They were used to splitting houses and cars, which don't disappear when the owner dies. They didn't realize that a 401k is a conditional asset that requires specific language to survive the death of the participant. This era also saw the rise of post-judgment litigation. When a spouse like Maria lost her $300,000 to a sister-in-law or a new wife, she would often sue her own lawyer for malpractice. The 1990s saw a massive increase in insurance premiums for family law attorneys because the 401k had become so complex that errors were almost inevitable. The potential outcomes for a lawyer who forgot to file a QDRO or forgot a survivor clause were career-ending lawsuits. This forced the legal profession to start specializing, leading to the rise of the QDRO specialist, who did nothing but draft these documents. As we look at the wreckage of these death of the decree cases, we see the transition into a more rigid, bureaucratic system. The chaos of the 90s taught the industry that the intent of a judge doesn't matter. Only the execution of the paperwork does. This realization fundamentally changed how Americans approached their retirement security during a split. It was no longer about fairness. It was about the technical precision of a federal filing. But what happens when the paperwork is perfect, the participant lives, and the market is high, but the 401k itself is a loan-heavy mess? As we move into the penultimate part of this masterclass, we explore the great 401k loan default of the late 90s. We will look at how couples used their 401ks as personal ATMs to fund the very lifestyles that destroyed their marriages, and how the IRS used those defaults to strip away what was left of the marital estate. What happens when the asset you are fighting over is actually a tax bill in disguise? Part 9 uncovers the ATM trap and the secret history of the 401k loan crisis that left a generation of divorcees in debt to the government. Stay tuned for the taxation of the ghost assets. The taxation of ghost assets in the late 1990s represents the moment where the 401k stopped being a retirement fund and started being a tax liability that could bankrupt both parties in a divorce. To understand this, we have to look at the ATM trap. In 1997 and 1998, as consumerism reached a fever pitch, many American couples began treating their 401k plans as low-interest personal piggy banks. It was incredibly easy to log into a workplace portal or call an HR line and request a 401k loan for home renovations, luxury vacations, or to pay down high-interest credit card debt. But these loans were predicated on a single fragile assumption that the participant would stay employed and married. Imagine a man named Stephen, a project manager for a telecommunications firm in 1998. Stephen and his wife Brenda took out a maximum $50,000 loan from Stephen's 401k to fund the down payment on a larger home. In their minds, they were simply borrowing from themselves. However, when they filed for divorce in 1999, that $50,000 loan became a ghost asset. Under the rules of the time, a 401k loan must be repaid with post-tax dollars from a paycheck. When the divorce court ordered the 401k to be split 50-50, the plan administrator looked at the account and saw $200,000 in stocks and a $50,000 IOU from Stephen. Here is where the historical trends turn into a nightmare. The plan administrator cannot split an IOU. They can only split the actual cash and securities. Consequently, the QDRO would often award Brenda $100,000 in cash and leave Stephen with $100,000 in cash plus the obligation to pay back the $50,000 loan. But if Stephen's income was now being squeezed by alimony and child support, he might not be able to afford the loan repayments. The moment he missed a payment, the IRS considered the entire $50,000 a deemed distribution. This meant that in the eyes of the government, Stephen had effectively withdrawn $50,000 from his retirement fund. Because he was only 42 years old, he was hit with an immediate 10% early withdrawal penalty of $5,000, plus federal and state income taxes on the $50,000. In 1999, for someone in a high tax bracket, this meant Stephen suddenly owed the IRS roughly $20,000 in taxes on money he had already spent years prior. He was being taxed on a ghost. This was the taxation of ghost assets, and it decimated the net worth of thousands of middle-class families who thought they were being fiscally responsible by borrowing from their own savings. The step-by-step failure of these loan-heavy settlements often began with the valuation process. In the 90s, many divorce attorneys would list the 401k at its gross value without subtracting the outstanding loan. They would see a statement that said $250,000 and divide it by 2. But $50,000 of that was already gone. If the non-participant spouse, like Brenda, was awarded $125,000, the participant spouse was essentially forced to pay out real cash to cover a debt they both incurred. This created a massive imbalance in the actual purchasing power each spouse held after the divorce. Furthermore, we must address the 1990s phenomenon of the involuntary termination default. In the late 90s, corporate downsizing was still a reality despite the tech boom. If Stephen lost his job during the divorce, his 401k loan usually became due in full within 60 to 90 days. If he couldn't pay it back, which almost no one could in the middle of a legal battle, the entire loan defaulted. This triggered the tax bill exactly when the participant was at their lowest financial point. Case studies from 1998 show a recurring pattern. A participant loses their job, their 401k loan defaults, the tax bill arrives, and because they can't pay the tax, the IRS places a lien on the very house they were trying to sell to finalize the divorce. Another layer of this crisis was the 401k loan offset. When a QDRO is executed, the plan administrator might reduce the participant's account balance by the amount of the loan before splitting the remainder. If the decree said Brenda gets 50% of the account, she might expect $125,000 but only receive $100,000 because the $50,000 loan was deducted from the top. Brenda would then sue Stephen for the missing $25,000, leading to a second round of expensive litigation. The 1990s legal system was stuck in a loop of trying to divide a pie that was shrinking due to hidden debts and tax penalties. We also have to examine the concept of basis and after-tax contributions. In the 90s, some 401ks allowed employees to make after-tax contributions. This created a dual-layered account. Some money was pre-tax and some was post-tax. When a couple divorced, they rarely tracked which was which. If Brenda received the pre-tax portion and Stephen kept the post-tax portion, they might appear to have equal amounts, but Brenda would eventually owe 30% of her share to the government, while Stephen would owe 0. This lack of tax affecting the assets led to a generation of divorcees who felt cheated when they reached retirement age and realized their half was significantly smaller than their ex-spouse. The depth of the ATM trap also included the 401k hardship withdrawal. During a contentious 1990s divorce, one spouse might claim a financial hardship to withdraw funds to pay for legal fees or basic living expenses. The IRS had strict rules for what constituted a hardship, and getting a divorce was not one of them. However, people would use threat of foreclosure as the excuse. They would take out $40,000 to save the house, but after taxes and penalties, they only received $25,000. They were burning $15,000 in future wealth just to keep a temporary roof over their heads. This was the ultimate victory of short-term survival over long-term stability. This leads us to the 1990s hidden dividend of the 401k. Many people didn't realize that their 401k was earning dividends that were being automatically reinvested. During the year-long process of a divorce, those dividends could add up to thousands of dollars. Without a specific clause in the QDRO that addressed earnings and losses from the date of valuation to the date of distribution, one spouse would often walk away with all the growth while the other received a stale, fixed dollar amount. In the high-growth environment of 1999, this error alone could cost a spouse $10,000 to $30,000 in missed gains. As we look at the wreckage of the 401k loan crisis and the taxation of ghost assets, it becomes clear that the 1990s was a decade of financial illiteracy, masked by a booming stock market. People thought they were rich because their statements told them so, but they didn't account for the debt, the taxes, and the structural flaws of the QDRO process. The ATM trap didn't just take people's retirement. It took their dignity as they were forced into collections with the IRS for money they had already spent on a life that was now over. But as we reach the end of this journey, we have to look at the big picture. How did the 401k divorce crisis of the 1990s fundamentally reshape the American middle class for the next 30 years? What are the lasting scars on the generation that is retiring right now, in 2026? We have covered the legal traps, the market crashes, the bankruptcy shields, and the ghost assets. In the final part of this masterclass, we bring it all together. We will look at the final accounting, the long-term data on how 401k splits impacted the retirement readiness of men versus women, and the specific reforms that finally brought some sanity to the system. But most importantly, we will reveal the one secret that savvy investors in the 90s used to protect their assets that is still legal today. You need to see the conclusion of the 401k deep dive to understand why the 90s was the most expensive decade to fall out of love. Stay tuned for the final part. The legacy of the split. The legacy of the split is not just a collection of historical data points. It is the blueprint of the modern American retirement crisis. As we sit here in 2026, the consequences of the 401k divorce battles of the 1990s have matured into a stark reality for millions of retirees. To understand the final accounting, we must look at the long-term case study of a generation. In the 1990s, the 401k was sold as the ultimate tool for financial independence. But for those who went through a divorce during that decade, the tool often turned into a trap that permanently lowered their standard of living. The first major takeaway from the 1990s legacy is the gender wealth gap in retirement. Historical trends show that women who divorced in the 90s were significantly more likely to suffer long-term financial instability compared to their male counterparts. This wasn't just because of lower wages, but because of the specific way 401ks were divided. As we discussed, many women took cash outs or used the QDRO to fund immediate needs like housing or education. While this solved a problem in 1997, by 2026, it meant they had missed out on nearly 30 years of compound growth in the most aggressive bull markets in history. A $50,000 withdrawal in the late 90s represents a loss of nearly $500,000 in potential retirement assets today. Imagine a woman named Cynthia who divorced in 1995. She received half of her husband's 401k, roughly $100,000. To provide stability for her children, she withdrew $40,000 to pay off the mortgage and keep the family home. In her mind, she was securing an asset, but the house required maintenance, property taxes, and insurance, all paid for with after-tax dollars. Meanwhile, her ex-husband kept his remaining $100,000 in a tax-advantaged 401k, allowing it to double every 7 to 10 years. By 2026, Cynthia's home is worth more, but she has no liquid cash to fund her daily life, while her ex-husband has a multi-million-dollar portfolio. This is the liquidity versus equity trap that defined 1990s divorce settlements. The step-by-step reality of the final accounting also reveals the impact of passive negligence. In the 1990s, the concept of a target date fund didn't exist in the way it does now. Participants had to manually manage their 401k allocations. After a traumatic divorce, many people simply stopped looking at their accounts. They were in survival mode. Case studies from the early 2000s show that thousands of divorcees left their 401k money in stable value, or money market funds, because they were afraid of the volatility that had just wrecked their marriage. By 2026, these individuals find themselves with balances that haven't even kept pace with inflation. They didn't lose their money to a spouse. They lost it to their own fear and the lack of professional guidance during the transition. Furthermore, we must address the 1990s secret that savvy investors used to protect their assets: the premarital segregation. While many people commingled their premarital savings with their marital 401k, a small group of individuals kept their premarital assets in separate, frozen accounts. Because they never added a single dollar of marital income to those accounts, they were able to argue in court that the growth on that money was also separate property. In the 90s, this was a high-level strategy that saved millions for those who had the foresight to keep their paper trails clean. Today, in 2026, this remains the gold standard for asset protection. If you don't commingle, the court has a much harder time claiming the asset belongs to the marriage. The legacy of the 90s also brought about the professionalization of the QDRO. After the chaos of the lost QDROs and tax ghosts, the legal industry realized that a general practitioner could no longer handle retirement division. This led to the birth of the Certified Divorce Financial Analyst, CDFA, and the QDRO Specialist. These professionals use actuarial math to ensure that the true value of an account, including the deferred tax liability, is accounted for. In the 90s, you split the balance. In 2026, we split the tax-affected balance. This shift has prevented a repeat of the 1990s disasters where one spouse walked away with 50% of the cash and the other walked away with 50% of a future tax bill. We also have to look at the Social Security trap for 1990s divorcees. Under U.S. law, if a marriage lasted at least 10 years, a divorced person can claim Social Security benefits based on their ex-spouse's earnings record, provided they are unmarried. In the 90s, many people didn't know this. They fought tooth and nail for a larger share of the 401k, not realizing they had a federal safety net waiting for them. However, for those who remarried before age 60, that safety net vanished. The decisions made in the 90s regarding remarriage were often made without understanding the long-term impact on Social Security income. In 2026, as the 90s generation hits their late 60s and 70s, this 10-year rule has become a massive factor in their quality of life. The 1990s also taught us about the danger of company stock concentration. The collapse of Enron and WorldCom served as a brutal masterclass in diversification. Modern 401k plans now have strict limits on how much company stock you can hold, but those rules were written in the blood of the 1990s divorcee. The legacy of the split is a more regulated, more transparent, and more bureaucratic system designed to protect people from themselves. But as we see in 2026, no amount of regulation can replace the need for personal due diligence. Consider the final calculation of the 401k loan crisis. We now know that 401k loans taken during a divorce are the #1 predictor of retirement failure for the middle class. The ATM trap of the 90s turned a generation of savers into debtors. The lesson is clear. If you use your retirement to solve a today problem, you are creating a tomorrow catastrophe. The 1990s showed us that the legal system is built for the today, but the 401k is built for the forever. When the two collide, the 401k almost always loses. As we conclude this deep dive masterclass, we look at the character of the American investor. The 1990s was a decade of optimism, where everyone thought they could be a millionaire by 50. Divorce was the reality check. It exposed the flaws in the paper wealth of the 401k era. It showed that a 401k is not just a number on a screen. It is a complex legal contract that requires a team of experts to navigate. The survivors of the 1990s 401k wars are the ones who prioritized record-keeping, understood the tax code, and realized that a divorce is a business transaction, not just an emotional ending. The legacy of the split is that retirement is no longer a solo journey. It is a shared asset that requires constant monitoring, even after the marriage is over. The ghosts of the 1990s still haunt the spreadsheets of 2026, reminding us that in the world of finance, the paperwork you don't sign is just as important as the paperwork you do. The 401k divorce in 1990s America was the fire that forged our modern understanding of wealth protection. But there is a new frontier of asset division that is making the 1990s 401k battles look like child's play. As we move into our next series, we are going to look at the digital divorce of the 2020s. How do you split a decentralized asset that has no plan administrator, no QDRO, and no physical location? What happens when the 401k of the future is held in a private key that one spouse forgets during the trial? The 90s was about the paperwork. The 2020s are about the code. If you thought the 401k was a nightmare, wait until you see the blockchain breakup. The era of the untraceable millionaire is here, and the legal system is once again 20 years behind. Stay tuned for the next deep dive into the evolution of American wealth and the new ways it is being torn apart.